Today it's Susanna and I, and we wanted to talk about a few issues that on first blush may seem straightforward, but too often in our daily practice, we see them being either misunderstood or being glossed over. And so we're going to pick on a few topics that we'll just call as a bit of a bugaboos for us. The first one is intestacy rules. Now, we're just not going to spend a lot of time on this, but we want to just walk through the intestacy rules just for a refresher. Some of us haven't looked at them as often as others because it hasn't come up. But one of the first rules that I always have when I get into an intestate situation is I always go to the legislation. And I know it sounds sort of archaic, but it's my only protection that I haven't missed something in terms of calculating the intestacy rules. So I cross-reference my family tree, and then I proceed to look at the legislation. And it's just a good habit. It's sort of like what we always like to say is we always like to look at the constating document. That's the will. Well, in an intestacy, the Section 47 of the SLRA is literally our constating document. So, Suzanne, I don't know if you had any opening comments, but let's work through this.
Yeah, I think that's always a very good suggestion for sure, just to make sure that we're not missing something, and particularly when it comes to, in what situations does representation come into play and when does it not? So when we start with, Section 2 or Part 2 of the Succession Law Reform Act, that actually addresses the intestacy provisions. And that's going to apply, of course, in a situation where someone doesn't have a will, so a complete intestacy, or where they have a will that doesn't completely dispose of their property. So you've got a partial intestacy in that situation.
So just looking at the basic rules, if the intestate is survived by a married spouse but no other children, then the deceased spouse is entitled to his or her entire estate. That's sort of the starting point.
That's right. And then it goes from there in the sense that Section 45 of the SLRA says that a surviving spouse is entitled to a preferential share of the estate in the event that there are children from the marriage. And so the value of that preferential share has been increased. It's presently at $350,000 in respect of any person who's died after March 1st of 2021. So March 1st of 2021 is the key for that $350,000 amount. But if someone has died prior to then the preferential share is going to be the $200,000 amount that was in play earlier.
And then the final cap on that, of course, is that if the assets of the estate do not exceed $350,000 and matches the facts that Susanna just described in terms of the date of death, the surviving spouse will receive the entirety of the intestate estate. And sometimes we get into situations where we have a modest estate and the costs of it, the expenses of it get heavily scrutinized always. But in this case, when you have a modest estate, because sometimes it is all actually just going to the surviving spouse.
Now, if the surviving spouse is going to survive the deceased and there's one child, then in that case, the estate's going to be distributed with the first $350,000 or whatever the preferential share is based on the date of death going to the spouse. And then the balance is going to be split between that one child and the surviving spouse. If, however, there's more than one child of the marriage, then the surviving spouse is still going to get her preferential share or his preferential share, together with 1/3 of the remainder. The other 2/3 is going to be split amongst the children.
So, of course, we can't forget that only married spouses are entitled to preferential shares, and of course, in the further percentage-based interest in the estate on an intestacy.
Yeah, and we saw that as of January 1st of 2022, separated spouses are now treated like divorced spouses, so they no longer have rights on an intestacy. I know for many years it was always a shock to my clients when someone would be separated from someone from their relationship, and yet notwithstanding the fact that the person's died and died without a will, they were still able to take, the preferential share and every other entitlement that came from being a married spouse. So this change has been brought about in order to bring separated spouses to be treated like divorced spouses. And, I think for many people, it was sort of a welcome change.
All right, so let's just talk about what separated spouses mean now under the legislation.
Well, the Act specifically provides a definition, and it says that if the parties have lived separate and apart for 3 years as a result of a breakdown in marriage, they've entered into a valid separation agreement under Part 4 of the Family Law Act, or there's a court order has been made with respect to their rights and obligations in the settlement of their affairs that has arisen following the breakdown of marriage. Test goes on further to say, or there's a family arbitration award that was made with respect to the rights and obligations as a result of the marriage breakdown. And at the time of the testator's death, they were living separate and apart as a result of a marriage breakdown. So in those situations, either two spouses would be found to be separated.
And mercifully, it was drafted with a view to keeping litigators happy, because the last part of it is the one that I love is, and that is, of course, that at the time of the testator's death, they were living separate and apart as a result of marriage breakdown. So we get to draw on a huge battery of law in terms of that question, because of course, separation is a factual determination, and what one might think is separate, others might think differently.
Absolutely. And we see lots of cases that have sort of unfolded just trying to address what that means. And, each party is going to play whatever side works best for them, depending on their particular retainer.
Absolutely. Okay, so that's just a good, healthy look at the rules of intestacy. And as I say, my practice is always look at the legislation when I'm calculating. So I went to law school because I can't do math, and this is a little bit of math. One of the things that I think the 3rd edition of my dad's book, and then since we've updated it since up to the 5th edition, it was included, is putting in a table of consanguinity. And we rarely have to go to it, and we're not going to spend a lot of time on it today, but just to identify the issue. Just what does a table of consanguinity help? What is it for? And where does it take us when we get into what I would describe as deep intestacy analysis?
Yeah. I remember the scary days of law school, and I didn't even know how to say consanguinity, let alone spell it. But it comes into play certainly when an intestate person dies without a surviving spouse. And then the assets have to be distributed in accordance with Section 47 of the SLRA. And that's where this whole table comes into play, because the legislation provides that, if a person dies intestate and they have no issues surviving him or her, then their property, subject to the rights of a spouse, if there were to be any, is going to be divided equally amongst his or her issue of the nearest degree. And it's figuring out what that nearest degree is when we start to consider having to turn to this table of consanguinity.
And of course, I wasn't organized enough to be able to share a screen with an illustration of the table of consanguinity, but if you are troubled by it, it does look like a little bit of a daunting analysis, but it's got we have a visual table in our edition of probate practice, and we'll continue to keep it because of this unique scenario. But I think it's just helpful that we remind ourselves when we get into situations like Susanna has described, what it looks like. So it maybe just spend a couple more minutes in describing what forgetting what the table looks like, describing what's involved with describing how to work a table of consanguinity.
Sure. I think the starting point is if an individual's direct line of descendants, if we're trying to figure out who that is, the individual is said to be 1 degree removed from his or her children. And then, so 1 degree removed from children, 2 degrees removed from grandchildren, because there's 2 different generations there, and then 3 degrees removed from the great-grandchildren. So that is that stepping stone in terms of the blood relation there.
And then just to sort of wind up this point, with intestacies, I always think of it this way, down, up, and over. And so and a table of consanguinity is just a more expansive analysis of that. So you've got the person, and you go down and you keep hitting zero. You've got no spouse, you've got no children, obviously no grandchildren or great grandchildren. So you have to go back up and start going over, because then you're going to go to the parents. So the individual's there, you're going to go up to the parents, and you're going to determine at the parent level the family tree. And this is important in terms of where we're going to be growing our family tree. And it's sort of it's a bit of an ancestry.com process in a way. But as I say, down, up, so we pop up to the parents, and then we start going over. And then we can start looking at brothers and sisters, nieces and nephews, great nieces, great nephews. And then even further over, you have to, if we're still at zeros, we can move over to the grandparent level. So we keep going up to the grandparent level. And at the grandparent level, we're looking for aunts and uncles, first cousins once removed, and so on. So what I like to do is when I get into situations where I'm past probably even the parents, I'm often hiring a searcher, an air searcher, to help me not just navigate a proper table of consanguinity, but navigate that I haven't missed anybody in the food chain, so to speak. So that's just sort of a very simplified way of looking at it, but one that it's anyway helps me understand it a little bit. Susanna, you mentioned partial intestacies. Can we just talk a little bit about that? Obviously, you've described what it is, but maybe we could expand a little bit on what a partial intestacy is and what role that plays in our analysis.
Right. I think the most important role that it plays, or is this whole married spouse's preferential share that applies, because it actually applies a little bit differently when we're in a partial intestacy situation. So the spouse is still going to be entitled to that preferential share, whatever the amount is under the legislation at the time. But if the will provides other benefits to the spouse, then we're going to look at the total of those benefits first. And if they outnumber the preferential share, then the spouse is not going to be entitled to anything further on account of that preferential share. So it's a little bit different than if we're just dealing with a straight complete intestacy.
And of course, a partial intestacy, maybe we could just use an illustration of what we might see where it might look like partial intestacy could occur in a will, for example.
Right. So if we had, let's say, $500,000 estate, and the spouse were to be entitled to $300,000 of the value of the estate, then he or she would be entitled to a top up to the 350. So a $50,000 top up, and then the remainder, the $150,000 beyond that, is going to be split depending on how many children there are. Either it's going to be 1/2 or 1/3.
Okay. Last point on this is just that resources are available on this. We have a slide share on Hull and Hull, just keyword intestacy in our slide shares that we have. We have a whole series of slide shares on topics, and that's one on intestacy. And then, of course, the succession law format, we're looking at sections 44 through 47, pretty much basically. And then estate planner on there, we've done an advanced webinar on that, just problems and solutions. So, okay, that's great. Well, look, we've kind of covered that one, and not bad in 15 minutes, a pretty complex area of the law, but we just keep going down, up, and over. Okay. What about, let's just talk about mistake and rectification. A concept that we hear about, and on the solicitor side, we never want to have happen, never want to be part of, but sometimes it happens. So if a mistake or rectification is relevant, what are we talking about, Susanna, from that perspective, just to give us that sort of a highlight of those two issues?
Well, I think what we're hoping for is that if there is a mistake that's discovered in a will, that the testator is still alive. Because the easiest way to address a mistake in that situation is just to do a new will, or perhaps a codicil to correct the error in the will. If, however, it's too late and the mistake is only discovered after the individual has passed away, then we're unfortunately looking at some kind of an application before the court.
Right. And the courts are generally, it is an application for sure, and it's one that you bring under Rule 14, and the courts are reluctant to change a will, which is good in a way. We say that now, but who knows what 21-1 is going to bring in the days to come. But that's that's for another day. But they're reluctant to change the will, other than to rectify it. in a way that better reflects the testator's intentions that were unclear due to an error. So that's the important thing. They're not going to want to change the will, but they're happy to, if they can be persuaded properly, to rectify what is clearly the intention.
And the only way that a court can do that here in Ontario is by either adding or deleting words. So where there's no ambiguity on the face of the will, and the testators reviewed it and approved of it and signed it, then the courts are only going to rectify a will and correct unintended errors in 3 situations. And we got that, the governing law on that, it comes from the decision of Rondell versus Robinson Estate, which was a 2011 decision of the Court of Appeal here in Ontario. And
yeah, and so why don't we just talk about the 3 components of it? And just to pause there, it's really important in my view anyway, I remind myself all the time that this is very different law than in the UK. The UK has specific legislation that deals with rectification that is different. So if you're going to be relying on UK decisions, be a little bit careful about that. That's why we like to come back to the Rondell decision, because of the importance of it, and it represents one of my many losses. So we'll talk about the 3 components.
So the 3 situations where a court will rectify a will include where there's an accidental slip or omission because of a typographical or a clerical error that's discovered in the will, or where the testator's instructions have been misunderstood by the drafting solicitor, or where the testator's instructions just haven't been carried out.
All right, so that just sort of sets the stage. I mean, we will talk more about rectification and the availability of it in due course, but it's not really I mean, it's a remedy that's available on the solicitor's side. I try not to get too into it because it really is a bit more of a litigation issue. So if we could just look at the other R word, and that is revocation of wills. And we've got a lot of resources on this as well, but let's just do an overview of that.
Well, we certainly know that with the new legislation that came into first on January 1st, 2022, that a will is no longer revoked by marriage. So I think that's the easiest starting point, because that was a huge change in our law.
And then of course, we want to deal with revocation in the context of execution by subsequent will, and that we are always very careful to draft that opening clause in our wills and making sure that our primary and secondary wills don't revoke each other. And that's a drafting issue, which we deal with an estate planner and catch that nuance for sure. And then, of course, there's revocation by physical destruction.
That's right. I mean, our legislation specifically provides that a will can be revoked by burning, tearing, or otherwise destroying it with the intention of revoking it. So that's the real key there. It's one thing if it happens by accident, you burn it or you tear it by accident, but if you do it with the intention of revoking it, then that's a valid revocation of what would otherwise have been a valid will.
And then, of course, lost wills, documents that were most of us will have a computer version of it, a digital version of it, but lost wills is another aspect of revocation, right, Susanna?
Yeah, because the original will is so very important when it comes time to probating. And if we don't have the original will, then we're going to possibly have to deal with the lost will situation, because there is this presumption at law that if the original will was last in the hands of the testator and can no longer be found after they passed away, then they are presumed to have revoked it with the intention of it no longer being a valid will. And so if any of the parties are intending to prove that this last will was in fact a valid will and it was not lost, then they're going to have to overcome that with some evidence to rebut the presumption.
And so let's just spend a couple minutes on lost wills and lost will applications, because of course, on the solicitor side, we do get dragged into these. And our role in them is not inconsequential. So, and this is where it becomes so important to record in writing where you have left the will. And if the will leaves your premises, that it's in writing that it's left the premises. So just to recap, the presumption is if the will was last in the hands of the testator, it is revocable, it's rebuttable, but it's presumed to have been destroyed by the testator. So if the evidence out of your office is that the will was sent for their own safekeeping and is lost, and you've got that letter that says you have the will and you put it in somewhere safe and it's not our job to keep, then you are going to leave yourself much less exposed to getting drawn in on the application for approving the lost will. Where it becomes problematic is if we can't trace where the hard copy of the will went. And unfortunately, we can get dragged into these on a law pro level because we could be blamed for not managing the custody of the document properly or creating uncertainty as to the custody of the document. So I can tell you what happens is an affidavit is actually filed with the court to describe the custody of the will. It's no different than in criminal law. They want to follow the document and be able to understand where the document was throughout the process. And so if you're resigning, if you're retiring, or if your practice is no longer to keep the wills, all of that carefully documented, or you might find yourself dragged into a discussion with your insurer to help solve a lost will application, which the gun might be pointed at you a bit.
I think it'll also be very interesting to see how these kinds of cases can apply with the new section 21.1 that you alluded to earlier, and whether or not, we can prove a lost will and have section 21.1 come into play. And the case law I know is certainly still unfolding, but I think it's exciting. So it's an opportunity where that provision may come into to be used by some of the parties.
It's sort of like the unforeseen consequences of the change to the capital gains tax that are starting to trickle out slowly. I saw an article in the Globe today, everyone's selling their cottages. That 21.1 is kind of merging the law a little bit with lost wills. And we might get to a point where, as we've already seen some cases where very factually frail documents are turned into wills. So we can see how the lost will law is going to sort of, I think, my guess is it's kind of going to evaporate a bit because of that. But that's a guess, and I'm never going to wear a sash, so I'm going to keep guessing. Suzanne, can we just talk about, just as we're winding up here, can we just talk about revival of revoked wills and what's available there?
Sure. We've got section 19 of the Succession Law Reform Act that will provide us with guidance and says that a will that was previously revoked can be revived by a valid will or a codicil if the testator expresses this intention to give effect to the revoked will. So as long as that intention can be expressed, we will be able to possibly save a will. The safest way, of course, is to have a revoked will, is to just re-execute it. And that way there'll be no question as to whether or not that intention was actually there or not, because it'll be as clear as can be.
I like your attitude. Okay, just as we're winding up, I want to just talk briefly about a concept that we throw around as solicitors a lot, but clients want to know how fast does an estate have to be administered? And maybe you could let's talk about some supporting authority to this, because it is this whole idea of an executor's year. What does it mean, and what kind of force and effect does the concept have, and maybe some of the law that's surrounding it? So why don't we just mention that?
Well, we know that where there is a situation where there's a will, there is a common law rule that the executor is going to administer the estate to the extent that it's possible within the 1 year from the date of death. And so in that case, if the estate is wound up and bequests are paid out, then no interest is going to accumulate on any of those gifts if it's paid out within a year. It's when it goes past the 1 year, when people start getting a little bit antsy and want their money a little bit quicker and they want it with interest, that year becomes important.
And of course, there is authority for this. If you ever want to look it up, there's a case called Currie versus Currie Estate, and it's spelled Currie versus Currie Estate. It's an old case, but it talks about the duty of an estate trustee with respect to the realization of assets. And that's when not when, but that is where the term executor's year gets thrown into the context of this. And that's in large part, that law is developed to really give you a benchmark as to what the court is going to expect in terms of administering an estate.
And I would just add to that, that if there is no will, then that executor's year is not going to run from the date of death, but it's going to run from the time that that certificate of appointment of whatever nature is obtained by the representative of the estate. So, because up until that point in time, no one really has the authority to do anything. And so it extends the time when the executor's year starts ticking from.
And just, we try to follow the chat, but you guys have sort of answered some of the questions yourselves, which is great. But one of the things that's being raised is this, and we're just going to come back and finish this thought. So this lost will stuff is becoming a bit of a quagmire. So the question is, if the deceased had an original will and it can't be found, and it was last in the hands of the deceased, all right, that's the evidence. So you have a letter that says, here's great client, you're fantastic to work with, here's your will, and that's the last communication you have, except for a check back to getting paid. Then the deceased dies, and efforts are made, and significant efforts have to be made, serious efforts have to be made to locate the original, and you still can't find it. And at that point, of course, on the face of the law, it appears that that's a will that's presumed to have been destroyed by the deceased. And this is where, and I don't want to get too into a rabbit hole, but this is where Section 21(1) problems are starting to arise, because you have a situation where the regular lost will law has been sort of, the boxes have been ticked, and so should you just proceed to an intestacy, or likely you're going to have a digital copy of the will, or you might have a photocopy of that will, and what then do you do? Because of course, it's on the face of it looks like that it's presumed to have been destroyed by the deceased, and yet the two problems you have, one is that what do you do about, do you go to court, do you not? And secondly, what do you do about the fact that you've got 21(1) and you've got cases out there that are making napkins into wills?
Yep. I mean, it's really going to be a question of what the risk tolerance is of the client, right? We know that if there's this presumption, if you feel you've overcome the presumption, then there's a result. If you feel you haven't, if you're prepared to take the risk, and if the client's going to swear an affidavit where they're going to say that there was no will, ultimately it's their decision. Of course, they're going to be looking to us for guidance on it, but as a counsel of caution, if it's close, I'll always recommend just seeking a declaration from the court, because there's no downside in that case, and a lot of negative if you're wrong.
And I think Section 21(1) gives you this opportunity. That is, you go, if the facts are so clear that the will has been last in the hands of the testator, then we used to have a conundrum. What should we do? Should we bother spending the money to go to court and saying it's a lost will or not a lost will? But because of 21(1), we might have an obligation to go to court and say, either tell us it's a lost will, or tell us that this will is sufficient for the purposes of 21(1) to be a valid will. And so we're really going to find more and more of these facts unfolding. But we just hit 1 o'clock. We want to thank everyone so much for joining us. We've got a fantastic seminar next week. We've got, I think Ian Labane is joining us, and it's going to be a specific about residence trusts and so on. But we'll get a notice out on that once we've locked it down. So thanks everyone so much. A great time, and thanks so much, Susanna, for your help.
Thanks, Ian. Thanks, everyone. Have a wonderful day.